So now I have the honor and pleasure of introducing to you Rostin Behnam, the current CFTC chair, who was sworn in as the 15th CFTC chair on January 4th, 2022. Mr. Behnam and I are probably the only two individuals here who knew your 14 predecessors and have worked closely with them. So I'm not trying to age either Leo or myself. The chair is also in his capacity, in another capacity, he sponsors the Market Risk Advisory Committee at the CFTC. And as many of you may know, that particular advisory committee is really designed to make sure the markets operate transparently and fairly and evaluate the various risks that might be associated either in the markets or the underlying risk of DCOs, DCMs, intermediaries, and et cetera. He's also was responsible for, we're going to talk about this as one of the questions I have for the chair, make sure if I get this right, the Climate Related Risks Committee or something like that, which I'm sure you will be able to talk about when we talk about carbon and so forth. Before he became the chair, he was a commissioner at the CFTC, and before that, he was special counsel to Senator Stabenow, who, as you may all know, is the chair of the Senate Agricultural, Nutrition, and Forestry Committee. He got his undergraduate degree at Georgetown University and his law degree at Syracuse University. And I don't know whether he has any responsibility for this, but both of those universities just recently hired 2 basketball coaches. So I don't know if you had anything at all to deal with the change of coaching at those 2 great universities. So what we have done is I put together a list of questions and open it up for the chair to talk, and let's have a nice little fireside chat. Okay. So are you ready? Okay. So what I call crypto or digital assets have gotten a lot of publicity recently. And there's been a rush of enforcement actions, to be honest, a little bit more by the SEC, but the CFTC has been involved in some. And to me, being involved in this industry for 45 years, I really believe there needs to be a legislative fix. So it's a 3-part question to start. Do you believe Congress will act? And if so, what will that law or legislation might be? When might it occur? And more importantly, does the CFTC have the budgetary resources to, if any such legislation does come about?
Ron, first, thanks to be inviting me. It's good to be here. It's good to see everyone. Leo, it's good to see you and some familiar faces out there. I see my NFA friends. I would say I'm not going to predict timelines, especially with Congress. It's too difficult. But what I am encouraged by is over the past, 2 Congresses, so 3-4 years, there's been a lot of interest and time spent by members of Congress and their staff to think about this emerging market, where it fits into our current regulatory framework, whether there are gaps and whether things need to be addressed to, whether changes need to be made to address the unique characteristics of digital assets, vis-a-vis securities, commodities, and banking regulation. So last year, there was a lot of momentum on both the House side and the Senate side, bipartisan support for several bills. And I think after FTX failed, I think there was a little bit of a pause because folks wanted to, sort of take stock of what bills were being filed, what bills had been filed, and whether or not some of the lessons learned from FTX were properly or appropriately addressed in some of the proposed legislation. And I think also that event, coupled with the events of earlier 2022, namely Three Arrows failure, Terra Luna, and some of the other sort of structural issues that we had experienced in the crypto space, I think empowered some in the constituency that really don't believe in digital assets and don't think that it's going to be a part of the future of the economy. And I'm not taking opinion, just sort of sharing my views from the outside. But it also, the events of 2022 also, I think for those who either believe in the technology or believe in, putting a regulatory structure around financial markets and digital assets, that also, the events also empowered them to say, you know what, this is proof that we actually do need to do something. So a mixed bag. And I think we're in a situation where there are rumblings of more bills being filed or variations of old bills being refiled in the next couple months, which is very positive. But whether or not, you got the Senate to agree, the House to agree, and then the president signing a bill is those are a lot of steps. So the administration's very proactive in wanting to protect customers and protect market resiliency and financial stability. I think members of Congress care about that, but there are larger questions about the state of the crypto markets, how they're going to fit into the U.S. regulatory system, and whether or not, quite frankly, a regulatory change is made. I've made the case that we do need something on the commodity side. My friend and counterpart at the SEC feels that compliance, and I agree with him, compliance with the securities laws is appropriate, but the question really becomes, what's a security, what's a commodity? And then also thinking about stable coins and some of the other nuances of the technology that should be thought about from a policy perspective.
So last was a week or two ago, recently, I should say, that you appeared before one of the House subcommittees about your new budget request for this coming year. Any thoughts or update yet on whether or not, to me, it was a very modest request. You should have been more aggressive. But any update on whether or not that will be granted? And if there is new legislation, what is the next step for the CFTC to even ask for more resources?
And I apologize for not answering that last part of your question, but so our current budget is $365 million. The request is $411 or $410 million. And I don't disagree with you, Ron, that we could certainly use more resources, but as with any well-managed organization, my opinion here, and thinking about the incremental growth of an organization, you should only request as much as you can handle, right? So my request is currently 411,765 full-time employees. We're currently we're just shy of 700. I have to think about going to Congress and saying, I need this much money in order to fulfill my mission, and I'm going to actually fulfill what I'm requesting, right? So if I ask for money to hire 765 employees, I better hire 765 employees. And if I can't, then Congress is going to say, well, Chairman, why did you ask us for money that you're not using? Or why should we give you more money next year if you can't even use the money you asked for last year? And then also just building infrastructure, signing contracts, data, cyber. I mean, these things all take time. So that's the sort of responsible way of requesting budgets, is incrementally. I think the target we had was about 12% increase over previous year's budget. But do I think we have enough money right now? No. I made a pretty strong case to the House Appropriations Committee that we serve taxpayers well, and we return the taxpayer investment multiple times. And I'll give you a quick statistic. In FY22, fiscal year 22, which ended on September 30th of last year of 22, little quirky fiscal years for the government, our budget was $320 million. So it was the end of that year. We're now in 360, but at $320 million, we assessed 2.5, just a smidge. There's a little bit over that, but I'm just going to give you a rough number, $2.5 billion in penalties, in enforcement penalties. Some big cases around communications between some financial institutions, some big cases in crypto. But just think about that number, right? $320 million budget, and we returned $2.5 billion to the general treasury. So if you talk about a good investment for the US taxpayer, I feel like the CFTC is a really good investment for the US taxpayer.
But in addition just to the FTEs, to me, the need to have the technology costs today is just tremendous. I'm on the NFA board and we spend a lot of time focusing on the increase in technology just on that organization, whether it's cybersecurity or with all the data that you receive and the ability to use technology to understand and analyze that data, to me is a tremendous cost.
Costs have skyrocketed as we've all sort of felt the pinch in our pockets over the past few years, but particularly in the data space and the cyberspace. And, you know, these contracts roll over every few years and they become sort of shocks to your budget as you see a 10, 20% increase in the previously signed budget. And then as you can imagine, and this is the natural sort of characteristic of a government agency, you know, we move like a ship. We are not particularly nimble. So you have the individuals and the institutions we regulate allocating huge amounts of their budget and their resources towards data management, towards technology. And if we're going to be an effective cop, right, putting aside our regulatory responsibilities and policy responsibilities, if we're going to be an effective cop using our enforcement tools, we need these resources for surveillance, for technology, for market oversight. And it's a constant sort of catch up. And this is not new to me. This won't be new to my successors. This is just the nature of the official sector, the government. But I do think, you know, as a single agency overseeing huge markets that have huge impacts on, you know, everyday people, but also large institutions and economies, we are a very good investment for the U.S. financial markets and the U.S. economy.
So you just mentioned the stable coins and other potential digital assets. To date, however, from a cases point of view, only Bitcoins and other have been deemed to be a commodity. And as we all know, a financial product has to be considered or fall within the definition of commodity in order for the commission to have jurisdiction. Can you please share with everyone whether the CFTC might or will issue a guidance or interpretive notice regarding whether it believes other types of digital assets might be so classified, or is it waiting first for Congress to act? And just to add to that, in the Binance complaint, you did mention a third tether as a potential. Any chance that the commission will be issuing a guidance or interpretive notice?
Well, I think it's important to just sort of understand, you know, we have a number of documents out on our website, advisories and guidance on the crypto space and what individuals and institutions can do to both comply with the law, but also the risks associated with participating in these markets. We work closely with NFA. They put out a number of advisories themselves. We do that in concert to make sure that we're reaching as many people as possible. But you mentioned Bitcoin and Ether, and those are not coincidentally the two coins that we have listed futures on. And we've had listed futures on Bitcoin and Ether going back to 2017, and for Bitcoin, and I think either 2018 or 2019 for Ether. So essentially, by having a contract listed, a futures contract and a swap or an option listed on a CFTC regulated exchange, you're essentially de facto making an interpretation that that asset and its underlying commodity, or the underlying asset, is a commodity. This has not been challenged, and again, these products trade. The one coin that has the sort of clearest determination of whether or not or how it should be classified is Bitcoin, and it's because we've had at least an Eastern District of New York court case. A judge issued a decision back in 2017 or 2018, and just check my dates here, that Bitcoin is a commodity. There was at least another decision, I think, in New England, maybe in the first district. But that, in the absence of congressional action, is the clearest and most firm sort of determination of how we characterize these coins. Other than that, the process at the CFTC, and this is not unique to digital assets, to list a contract is twofold. One, you could self-certify a contract. So if someone wants to list a contract on corn or crude oil or natural gas or a metal or a financial future, you work with the agency, you follow the sort of parameters and the principles that we require, and you ensure that it complies with the law, and then you self-certify the contract. So it's a It's a process that was born about 23 years ago, and it's shared responsibility between the exchange, which lists the product, and the agency to ensure that the exchange is complying with the law. There's also a second process that would require the commission, including myself, to take a vote on whether or not the product should be approved for listing. So those are sort of processes which require legal analysis and which require a relationship between the registrant, the exchange, and the commission to make a determination. Thus far, there are no other listed contracts on digital assets, but that's not to say there won't be in the future. But I will make very clear that whatever we do, and this is not, again, unique to digital assets, there is a very thorough, exhaustive legal process and legal analysis around the underlying product to ensure that it falls within, to your point, Ron, our legal jurisdiction. So that is one sort of area. The other area you mentioned is enforcement, which in many respects is unique from the policy side of the agency, but obviously very much a part of the agency as well. And we have mentioned, we brought a case against Tether, a stable coin, not a digital coin itself. We brought cases, the Binance case, we made, I believe it was Bitcoin, Ether, and Litecoin in addition to Tether. So these are functions of the existing law and how we classify sort of virtual currencies. There was an advisory put out in it could have been January 2018. I remember it being right around the new year. And I was a commissioner back then, but we were very explicit in terms of wanting to demonstrate what coins constitute a commodity under the Commodity Exchange Act. So that's the general thinking. I don't anticipate putting out any new documents to further define. I think it's a sort of organic process of markets and who and what want to list contracts, and then that sort of rigorous analysis that takes place between the market participant, the exchange, and the commission. And we certainly are not going to bend rules or be loose with our interpretation of the law. We've been doing this for decades, and we are very firm and strict with how we interpret the Commodity Exchange Act and specifically the definition of a commodity. And then obviously enforcement cases. And I will end with this: is ultimately my first choice is Congress acts and helps us sort of frame the definition, because the Howey test is certainly a good guidepost if we think about from a very macro perspective of what we think security should be and what a non-security is. But there are characteristics to these assets which are so unique, and that I think it deserves, at a minimum, a discussion among policymakers.
Personal note, I hope you get all the jurisdiction and not the SEC, but I won't ask you to comment. So I am a really big supporter of diversity and inclusion. And in the prior panel that was sponsored by Women in Derivatives, it was just an excellent discussion on the current banking situation crisis. And I have had the honor and privilege of working with two of the panelists that spoke. I also know that you're a big supporter of these matters. Can you please share with the audience the initiatives and goals of the commission in promoting diversity and inclusion there?
Yeah, thanks for that question, Ron. When I was a commissioner in my dates are fuzzy here because there was so much that happened. 2018, I think, I wrote a public letter to our head of OMWI, which is the Office of Minority Women Inclusion. And I did it in a respectful way. It wasn't a gotcha moment. But I asked a series of questions about our diversity statistics and, what were the makeup sort of the agency. And unfortunately, and I don't think this is necessarily unique to the CFTC, but we are unique in the sense that we're a smaller agency. We have about 1,000 full-time employees, 700 full-time employees, 300 contractors, so 1,000 total. And if you look at the sort of org chart, we're not terribly diverse. We weren't then, but we are making improvements and changes to increase that diversity. So I looked at this org chart, I wrote this letter, got some statistics back, and started to make this a sort of priority of mine. When I became chair, I had the authority. When you become chair, you can actually make the decisions and implement policies. I created our agency's first chief diversity officer, Tanisha Cole Edmonds, which I'm very proud of, and she's been doing a lot of great things for the better part of a year. And what we're doing is both changing our sort of institutional mindset of how we recruit and how we think about the candidates that we select. And this is and I don't want to be hypercritical at all of my predecessors, but this was in part at least a product of our budget issues. We grew significantly after the financial crisis because Congress gave us authority over the swaps market, which was essentially OTC derivatives market prior to 2008 to 2010 when Dodd-Frank was signed. So we got this huge new authority. Our budgets did go up, but then they sort of flatlined in about 2015 and they were flat for about 5 years. And running an organization, you really feel flat budgets in the present day, but it has impacts for a lot of years after you have those flat budgets. So we've actually gotten quite an improvement in our budget and a recognition by Congress that we're an important regulator, but I still see the scars of those years where we were flat budgeted. And what happened was you're flat budgeted, you can't hire new people, morale is low, you have natural organic attrition. But when someone leaves, it's like, oh, we got a spot. It's like, because you're not hiring anyone new. So once someone leaves is the only time you can hire someone. So it becomes this very prized position and everyone sort of, gravitates towards who's going to be able to hire this position and who are we going to get. So over a number of years, we hired excellent attorneys, typically some economists, some data analysts, but you end up picking from a very small cohort because you're like, this is the one position we have. We have to get the best possible person. So you end up getting this very, seasoned individual who's been in the derivative space for a long time. And that's great because those are experts. We are pleased and privileged to have them, but it really prevents you from casting a wider net and building a bench and finding young individuals who want to learn about derivatives markets and who want to be a part of public service, which is an amazing job and amazing opportunity. And I'll give you an example. 2 of my 4 staff, at least when I was a commissioner, I have a much bigger staff now as chair, they've been at the agency for 20, 25 years. And they started as, entry-level enforcement attorneys, worked around different offices, enforcement, intermediation, general counsel's office. And those are the stories I love, right? Like committed public service individuals who love what they do, who are really the best in terms of experts globally, and have this commitment to this agency. And we have such a broad constituency from farmers and ranchers to manufacturers, insurance companies, financial institutions, that we have this ability to really cast a wide net across the country, both in urban areas and rural areas, because we have ag economists. We need ag economists to help us with our ag futures contracts. But we have a diverse constituency where we want to think about how our markets affect urban areas in low income communities, especially with climate issues. So we are trying through Tanisha and this chief diversity officer to be more intentional in how we recruit and making sure that we're doing it in a fair way and an equitable way so that we have this great bench of staff who are going to be the next leaders of the CFTC in the next few decades.
Yeah, I share your passion. At every NFA board meeting, we have update on diversity and inclusion at the NFA, and it's such an important goal, in my opinion, for the industry to go against. And with respect to your 65 new full-time employees that you're on, I have a lot of current and former students here that we can easily fill those 65 slots. So just don't even have to reach out. I will take care of that for you, okay? All right, our next question, as you know, everyone in this room knows, the derivatives industry is clearly a global one. So can you please share your initiatives on how the commission deals with non-US financial regulators in an attempt to possibly create a more harmonized regulated world?
Yeah, so I'm going to start with this. Many of you may, or some of you might be familiar with IOSCO. It's the International Organization of Security Commissions. I'm the vice chair of IOSCO. So there's a chair and then I'm number 2. And this was something that I was very excited about the opportunity and very obviously feel very privileged that the board of members, approved my candidacy. But yes, Ron, derivatives markets are global in nature. We have huge impacts on markets across different regions around the world. And the way financial institutions operate these days, it is so important that we have as much synergy between different jurisdictions as possible. Now, naturally, you're going to have a delta between regulatory structures in different jurisdictions. And I think the goal is to always lift up jurisdictions and not race to the bottom. And oftentimes you can achieve that. Sometimes you can't. But I think among larger economies that have large financial economies and also financial markets, we tend to work, through G7 or the G20 and then these multilateral organizations to ensure that we are stepping up and raising the bar. And we use these multilateral organizations as a tool to get together quite frequently, actually, at 7 a.m. for me, which my wife does not appreciate. But to have these conversations with Europe and Asia and different jurisdictions in Africa and South America to make sure that we are, to the best of our ability, drawing as much of a straight line between our regulatory differences as possible. And how does that manifest itself? I'll give you a quick example on the crypto space and even climate to an extent. You have a new issue that's creating a new pocket of risk, or you have a new market that's emerging. How do we use these multilateral organizations to set a baseline structure around market regulation, right? And then off of that foundation, you then implement it at your national level, depending on what jurisdiction you're in. And it often works very well and effectively. You're naturally, like I said, going to have differences, but ultimately you're trying to focus on principles and you're trying to focus on outcomes, right? So how do we achieve the same outcome, regardless of whether or not the specific prescriptive rules might be modified because of the different jurisdiction? And what's one of the most interesting things for me to observe, and I had the privilege of traveling a bit as a college student and maybe in my 20s, but seeing the cultural differences between countries manifest in regulation is fascinating. And it really does, right? And whether it's Asia, the Middle East, or Europe, or the US, it is almost so obvious how our cultural stitching and system ends up sort of being manifested in the way we write rules and the way we conduct ourselves from a business standpoint and an economic standpoint. And I think it's a great thing, right? Because in many respects, it's almost predictable, but it's also the sort of beauty of the differences and the similarities we have. So that's one example on the crypto space of where you have a new issue. For us at the CFTC, and I'll give this last example to that question, is Dodd-Frank, swaps regime, with help of NFA, of course, there's a number of rules that we had to implement, registration that we had to implement, but then you end up having, and this is not unique to swaps, but I'm just giving an example because it was the most recent sort of implementation. You have these new rules, you have to implement them, and you start to have either equivalence agreements or you start to have comparability agreements. And essentially what that means is, US jurisdiction, and I'll just use the UK as an example, not picking or selecting them for any one reason, but they have a set of rules, we have a set of rules. They're not, perfectly symmetric, but we're trying to achieve the same outcome. So through a memorandum of understanding or some sort of agreement, we sit down at the staff level and then at the principal level and say, we're trying to achieve the same outcome. This is what we agreed to in the G7 or the G20 or through IOSCO or the Financial Stability Board. Let's enter into an agreement so that market participant A, bank, A, you name it, FCM, whatever it is, doesn't have to comply with two sets of rules. We're going to make it as seamless and easy as possible for this global institution to operate in both jurisdictions without having to spend a whole bunch of resources and a whole bunch of people registering and complying with each unique rule in each jurisdiction, even though you're ultimately trying to do the same thing, but the specifics are slightly off, right? So that's a great example of the cooperation and the efforts that we take, which are actually very time consuming, but also very rewarding, to make sure that we're creating as much of a global non-fragmented market so that these institutions can operate in as seamless as way as possible. And I don't mean to suggest that I'm trying to make life easy for these financial institutions, but ultimately what we're trying to do is make it easier and more cost effective, because if they're able to do their job in a safe, regulated, transparent way, that essentially equates to lower costs, better hedging tools and mechanisms, which allow end users, farmers, ranchers, manufacturers, pension funds to operate globally and provide services for all of us at a, more in a more effective way. Now, that's the theoretical like idea. I think it generally we accomplish that, but there's always, some ups and downs that we're always trying to navigate.
So I share your thoughts about the culture. I've had many opportunities to go around the world and speak before financial regulators, and as most of this is post Dodd-Frank, and no way would they be anywhere near getting to the level of what we have here, but they're trying to increase to a certain extent without impacting their local community of how to have better regulations and protecting customers. But culture, as you said, does play such a huge role, and we don't always understand that. We have such a different approach here in the US. So I have had the privilege of serving on the NFA board as a public representative for the last 13 years and served on its executive committee for several of those years. So I am biased with this next question. I think NFA is a very effective and user-friendly regulator. Can you please share your initiatives in working with the NFA and how the NFA works side by side with the commission in regulating our great industry?
Yeah, look, I share your sentiment, Ron. It's a great self-regulatory organization. It was in fact created, the CFTC, and you'll know this since you knew the first chairman and the current chairman, but we were created in 1975 by an act of Congress. President Ford signed the bill into effect. And we used to be a part of the Department of Agriculture, given our history with the agricultural economy. And the CFTC actually goes back to 1922, when the Senate Ag Committee first authorized the creation of the Commodity Exchange Authority within the USDA. But as you would imagine, markets evolved, products changed, and it made sense for multiple reasons to create the independent agency. But simultaneously with that creation of the CFTC, Congress authorized the creation of essentially a National Futures Association, or self-regulatory organization, which became the NFA. And they have been, I think it took a few years, maybe 1980, I forgot the exact 82. Yeah, because you just celebrated the 40th, right? Yeah, last year. They are a partner like no other. We have shared vision, shared mission in many respects. And I use this analogy, they are the boots on the ground, right? It is so critical for, especially, and I'll only speak to a financial regulator's perspective. Obviously the SEC has the FINRA, but it's just so important given the remit and the size of these markets and the number of participants in the markets down to the individual level to have an effective, impactful, well-run expert in a self-regulatory organization. So whether it's registrations, whether it's customer advisories, it's the rulemaking, the enforcement authority, just keeping a check on all of the institutions and individuals that participate in our market. We certainly could not even come close, right? So it is an essential component of our markets, but what's most gratifying is that the NFA has been top tier in terms of an SRO globally. They participate in IOSCO and they just are so effective. And just a few examples after Dodd-Frank, the work that they've done, implementing the swaps regime, education, outreach, and registration, ultimately in annual compliance. And then what we're dealing with right now in crypto, just being able to get advisories and customer education, and then really learn a new topic on the run and be able to sort of, we're getting we're getting a whole new constituency of participants, both individual and institutional, that we have to fit into our existing legal framework. And that's not easy, right? But NFA is able to do it very seamlessly. And we work as a great partnership from the top on down. And thanks to the board. The board's the best, right? I
I agree.
greatest board in the world. But yeah, it's fantastic, and we would not be effective or successful like we are without the NFA.
So Commissioner Pham in a recent speech praised the NFA in writing with the new Rule 251 dealing with the digital assets. So when can we expect something from you? Or are you going to wait to the May board meeting? I know you're making a presentation there. Are you going to wait to do it then?
I love fireside chats.
So we have a lot of NFA senior officers here. Did I do good? That it okay? Okay, all right. So this is something where maybe you and I might disagree on. So I am not a big supporter of regulation by enforcement. And to me, the Administrative Procedure Act that was adopted by Congress many years ago encourages and even requires regulatory agencies to propose new rules, guidance, and then seek public comment on them. Granted, I'm not asking you to comment on this, the SEC has been the more aggressive agency in the enforcement area, especially without any rulemaking. And to be honest, the commission has done a couple as well. But can you share?
I take issue with that comment.
But can you share your thoughts about this policy on regulation by enforcement at the commission level? And is it something we have to live with, or is it something that could be changed in the future?
So one, we don't disagree. I agree with you. I don't like regulation by enforcement. And two, I don't think that's what we do. And I think if you look at the cases we've brought, we've been very clear about violations of the Commodity Exchange Act. And there should be an expectation by individuals or institutions that participate in our market that you have to comply with the derivatives law, and that's it. And the only circumstance where someone could, and I'm not suggesting anything about the CFTC or otherwise, but the only circumstance where someone can criticize us for not facilitating a path to regulation is if in fact we don't engage and if we don't facilitate a path to regulation, if there is one, right? So if you think about our cases, and we brought a number of cases which have raised this question about regulation by enforcement, I would encourage all of you, the law students in the room, to read the complaints and think about there are communications among the executive teams at these institutions that we brought complaints against where they are just flagrantly acknowledging the law and violating it intentionally. So I don't view that at all as regulation by enforcement. And for anyone, I get that there's new participants, I get that this is a new technology, but ultimately it comes down to, if you can show me as chair that we as an agency, while I've been running the agency, have not facilitated a conversation, engagement, or a path to regulation, if there is one, because I'm not suggesting there is a path to regulation for everyone. If we have not done that and we continue to bring enforcement cases, then fine. Then we are in theory conducting enforcement by regulation. But I think that's not the case at all. I think the agency under my predecessors, both Giancarlo and Tarbert, while I've at the commission, and then myself, have been very open about engaging in the digital asset space. We've tried to facilitate conversations and help folks think about what their businesses are and what they're trying to accomplish. But under no circumstances do I think we have been sort of closed about having conversations and engaging. Ultimately, I'll end with this as well, is we think about the way the technology is evolving and how it fits into the current regulatory structure. It's difficult. I mean, it's not a perfect match. This law was drafted over decades, going back literally 100 years. So it does require a lot of intentional thought. There are burdens to registering with a federal agency. And we have to think about what is going to be where will the burden fall on the agency or the individual in the institution to make sure that we know how and in what context you need to register with an agency, right? If that burden was on an agency, I don't know, we can't meet that. We have to do the best we can with NFA to put as much information out essentially through the internet, right? That's our best portal at this point, social media. And then to an extent, if someone reaches out to us, there is a phone number to educate. But to expect us to be able to reach every corner of the world and meet that threshold test is impossible, right? We have to make sure we're putting everything out there. But if you're gonna be sophisticated enough to say, I'm gonna start a company and I'm gonna run an exchange and I'm gonna trade derivatives on them, and I'm gonna offer them to US customers, you know, even though it's crypto and it's not a corn or soybean or an oil or natural gas or a credit or a rate or a currency future, if you're gonna be sophisticated enough to put together a company, form an LLC or an Inc., get people together, yada, 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 you got to know that there's a regulatory structure around offering
I agree
derivatives in the
100%.
US. So
Okay, so there's been a lot of recent debate and discussion regarding ESG and carbon. And I'm a big supporter of the ESG and the initiatives. And to be honest, these issues have primarily been addressed by the SEC, but can you share how the CFTC is dealing with these issues? And if you could talk about this new subcommittee on the climate related matters for the audience.
So I'm going to take issue with that question too. And just to clarify, I do not run the Market Risk Advisory Committee anymore. I did run it, so I ran it as really?
Yeah.
I think there's a past tense there somewhere. I should, but we'll fix it. So I was head of the MRAC when I was a commissioner. I'm currently the head of a different advisory committee. But while I was a commissioner, I led a number of initiatives, one on LIBOR transition, which you may have heard about, one on clearinghouse risk. But then I led an initiative, and this is back in 2018 or 2019, on climate related financial market risk. Very different environment politically, and also I think sort of where the conversation about climate change and climate market risk is. So that initiative ultimately led to a report that was published in September of 2020. We had about 33 or 34 members, very diverse constituency from exchanges and clearinghouses and asset managers, NGOs, academics, good group. And I would encourage all of you, if you Google like CFTC MRAC climate report, it'll pop up. It's a 200-page report, unanimously supported by the members. And it really walks through every component of what financial regulators should think about as it relates to climate risk. So anything from disclosures, which was really, Ron, your point about the SEC, to data management, to scenario analysis, stress testing, financial institutions, to carbon markets and a carbon price. So very proud moment for myself personally. I was really pleased to be able to get that report out. And I think really exemplified, again, back in 2020, if you can imagine where the politics were back then on climate change, exemplified sort of the energy and the desire by the private sector to participate in this and to think about what climate change, what impacts climate change are having on our financial markets. So now as chair, this very broad report covers really the work of every possible financial regulator, prudential, and market. We've been focused on what we can do at the CFTC. So we had a convening at the CFTC last June, so 11 months ago, 10 months ago, and it was broadly about voluntary carbon markets, but we had discussions about other issues. We put out a request for information, like a consultation document, a few weeks after the meeting, and we asked a number of questions, I think like 40 questions, and we're just trying to gather information and get a sense from our stakeholders, but also the public, what can we do and what should we do as it relates to climate change and financial market risk within the CFTC. And we got everything from better disclosures, better data management, stress testing, clearinghouses, and then a lot of information about voluntary carbon markets. The interesting thing about voluntary carbon markets, not unlike crypto, we're seeing these emerging commodity markets that are becoming very accessible and fall within this gap between our two market regulators. Right? We are very unique in the US that we have two market regulators. In my discussions with IOSCO, I don't actually know of a single other jurisdiction that has two market regulators. And this is just a product of history. And we are in fact older than the SEC. So we came first. But ultimately we have this structure. I think it works very well. We have the two biggest markets in the globe. So it quite frankly, in my mind, makes sense that we would have two market regulators. But you end up creating this gap. And we've seen this gap sort of expose itself a lot in the past decade. And what it really is an underlying commodity market that's being traded on a sort of platform or an exchange like infrastructure, right? You typically have underlying commodities being bought and sold by wholesalers, and it's really governed by contract law more than anything else. But you have crypto now, and you have at least one, two, and maybe more commodity crypto assets that are trading on exchange like central limit order books or different venues. And then you have these carbon offsets, which are, under the Commodity Exchange Act, can be defined as commodities. And you're starting to see these markets emerge where you're having an order book and people being able to use their phones and buy and sell these assets. So it's a hugely important component of climate change and the transition away from fossil fuels. It's essentially the ability of, just use an example of a corporation has net zero target by 2050. They're not going to actually be able to get to the target organically to actually reduce their use of fossil fuels. So they'll purchase offsets in the market to offset where they're not able to reduce or transition to renewable fuels. So it creates an opportunity for the entity to hit their targets, but then it creates incentives for the market to take action that would sequester carbon. So you can imagine a landowner in the Southeast plants 1,000 acres of trees using some environmental metrics. You plant 1,000 trees. That planting essentially sequesters a certain amount of tonnage of carbon. And when you sequester a certain amount of carbon, you then generate a credit that has some value because of the amount of carbon you sequestered. So then you've just generated this credit, which by law is a commodity. And you then sell it to this company that says, you know what, I want to hit my net zero target. So the company then buys it. The landowner makes money. They're happy. They've created a business line for themselves, and then the company's hitting their net zero target. The question becomes, do they retire the target, which is a term which is used, so they kind of like bank it and they don't use it ever again, or do they potentially trade it and sell it to a secondary or a third party? And then that's where we would come in. So these are the things we're seeing emerge because of technology and because of new markets and things that I'm trying to identify as places where the CFTC can be helpful in this climate conversation.
So my next question, and this is a long-winded question, so forgive me on that, but it's something that is very important to me. And I don't know if anyone is more of a supporter of making sure customer assets are protected in the unlikely event of an FCM's bankruptcy. And we're unique. This country is unique. It was discussed a little bit in the prior panel of our bankruptcy code is very specific when a commodity broker and FCM files for bankruptcy. And there's another, in UK, they have what's called client money rules, but they're nowhere near what we have here. And most other countries don't have any laws whatsoever that are specific to assets held in a custodial way by a brokerage firm in those other countries. So my question to you as vice chair of OSCO or whatever, is there anything that you or the commission can do and maybe establishing what I call a global committee to address this? I agree with what you said earlier, the culture of the laws and the different countries will impact that. But my biggest concern, and it didn't happen with Lehman, even though Lehman was a global firm, but there's a potential for a large institution failing, and it's going to have global implications on the assets of the customers. Have you thought about, as an OSCO or any other organization, you talked about the G7, is there something that a new committee could be formed to start talking about this on a global basis?
Yeah, I mean, look, there's certainly no reason we can't do it. It's a good idea. I think, one sort of element that I recognize, and this shouldn't be a surprise, right? In many respects, not all respects, the global regulatory community looks to the US for leadership. We have the largest financial markets, both on the security side and on the derivative side. We have proven regulatory systems that obviously are bound and driven by the rule of law and the clarity and the sort of accountability that a clear legal framework comes with, which is obviously extremely important if you're running a business. And then obviously the focus on customer protections. And I was asked this question at an event at the New York Stock Exchange before this, and talking about crypto and how we're not retail focused and we don't really get down to the investor. And I've been taking offense to a lot of questions today, but like point being is like, if you really spend any time with the Commodity Exchange Act, Ron, to your point, you will recognize and see that it is literally built around customer protections. It is built around investor protections and making sure customer money is appropriately and clearly segregated, and that there is no issue or risk of customer loss. Naturally, we've seen that in the past, but that's because of fraud and intentional fraud. You can't control that. But you just create disincentives, obviously. But ultimately, some people commit fraud, and we see it time and again. It's cyclical, if nothing else. So I think that track record, that history, that precedent is really the best foundation to build off of in order to advocate for, sort of synchronized policy across the globe. And we see it, but really it does become a little bit of a diplomatic challenge, right? And that's an interesting part of my job is, especially with derivatives markets more than other markets, it really is global in nature, and it does demand a sense of diplomacy in terms of the way we engage with foreign regulators, and coming to agreement and understanding that there's going to have to be a give and take, right? Like we can't just force our position down everyone's throat, right? Like we have to understand that we're all in this together. We want to work together. And it requires a little bit of a soft touch, right? So for me to go around and say, hey, you should just, use our rules because they're the best, might garner some reaction.
Ask me, I'll tell them.
All right, I'll tell them to call you up. But I do think that, it's about setting an example. It's about proven track records and history, and notwithstanding these episodes of intentional fraud, as you pointed out with Lehman in 2008, our rules have been pretty steadfast and proven to be very effective.
So, at a recent NFA board meeting, Commissioner Johnson spoke to the board and spoke about different issues, and then she opened it up for a Q&A. And my question to Commissioner Johnson was, as an academic, and I'm an academic, how did that influence her position when she joined the commission? So let's look in your past and share with us how your prior positions influenced or helped you, first as a CFTC commissioner and now as a chair.
Okay, that's a good question. So I graduated college in 2000. So I've been out of college for 23 years, and I'll just quickly walk through some experiences I've had. First job was actually down the road, 50 Broad. I was a proprietary trader at an prop equity shop, and I did that for about a year and a half. This was 2000 to 2001, right around 9/11, obviously, and the experience there, and I've said this in a speech, I think recently, because I was talking about, probably someone asked me a similar question. In that year, I don't know if some of you probably weren't born yet or not. This was a frightening thought, but whatever. The tech bubble burst, and that resulted in a monetary shift in policy, which is ironic because we're going through it right now. But the then chairman of the Fed, Alan Greenspan, cut rates in January of 2001. And I remember being at my desk and seeing the screen just go green because it was a surprise cut in the middle of the day. You see these Wednesday FOMC meetings with Jay Powell now, and they come out with a number, right? So this was that 22 years ago. And the market had kind of been drifting down and a little flat, and they cut rates because the economy was a little soft. So that was just an interesting experience of macroeconomic impacts on financial markets and how financial markets reacted immediately to that change. Price discovery, right? The other experience in that job, technology was changing, and it was changing literally as I started. I started the job in July of 2000, and NASDAQ and then the NYSE, New York Stock Exchange, were going to decimals. So before decimals, there were fractions. So before all these high frequency traders and algo traders that trade for fractions of a penny, people were trading for eighths and quarters and tenths and everything in between. So you can imagine these guys were making a lot of money. Markets were moving a lot, and they were making, fractions, which you go from a fraction to a penny. You're like, where am I going to make my big? they were pretty upset. So I come in as a new guy and I'm like, okay, we'll figure this out. These guys were fearful of their existence because they weren't going to be able to make their budget. And that was just an interesting experience given where markets are now and the role of technology in markets, and how, you don't have brokers down at the New York Stock Exchange or even me banging on a keyboard. It's all, algo driven. And then the third experience was 9/11. I was downtown and then vividly remember, obviously not getting to the office that day, and the markets were closed for the rest of the week. So 9/11 occurred on a Tuesday. Markets didn't open up until the 17th, which is in itself an incredible concept. Given what we've been through with the pandemic and the war, markets were shut down for 4 days. That's nuts, right? 4 days. And coming back to the office on Monday, the 17th, there was a barrier around the whole downtown, and just getting to the office and seeing markets open on Monday at 9:30, there was a moment of silence with both the exchange and NASDAQ, and then, seeing transportation stocks and defense stocks and other sort of stocks react to that geopolitical event, right? So technology, geopolitics, and then monetary policy. So that was my first job. Then I went to law school. I interned in the Southern District my first year for Judge Sprizzo, who's since passed away. Second year, I interned at the CFTC in the enforcement division down here. They were at 180 Broad. They're now at 290, which was pretty cool. And then my first job was I was at the Attorney General's office in New Jersey. I grew up in New Jersey, just across the river. And I was an investigator at the Bureau of Securities in New Jersey. So did examinations and investigations, and then some corporate fin work for the state level securities bureau. Worked at a law firm in Midtown for a couple of years, started a company, and then went and worked on the Hill for 6.5 years, just in a policy position. So all that to be said is policy, markets, started a company, worked in law, and bias. But I think when I think about my job and what the responsibilities are, it in many respects doesn't demand, certainly, but it benefits from having those experiences, seeing how markets function and seeing how markets react to externalities and events. Starting a company and seeing the sort of real world challenges that people face when they start a company or they run a business. Working at a law firm and servicing clients to, form a fund or do public reporting, working as an investigator, sort of on the enforcement side of a regulator, and then working on the Hill. My favorite job still to this day, but just in that policy perspective. And growing up in northern New Jersey and not knowing about production agriculture and spending 6.5 years on the ag committee and meeting so many people from all across the country and having a much better sense of our economy and what drives it and the challenges that people face, and constituency interaction, right? And listening to people, because that's the most important part of my job, is to listen, to take meetings, to understand what people are dealing with and the challenges they're facing, and then having a filter and essentially making what I think are the best decisions for the agency.
So my final question, let's look in that crystal ball. And where do you share your thoughts is where the commission, in your view, and the industry will be in 5 years or in 10 years? And would the commission be bigger than the SEC at that time?
I don't think that will ever happen. It's so interesting to be a part of the agency now. And I think a lot of the things that we're seeing, disruption in markets, new players, new products, new market structures. A lot of the issues we're dealing with right now are market structure issues. And we dealt with non-intermediation with FTX, right? And that's not going to go away. I mean, technology is disrupting markets in so many different ways. So it won't necessarily happen on my watch, but at some point, I think we're going to see these seeds germinate and sprout, and you're going to start to see a lot of new products, risk management products. I've seen a lot of younger folks come into my office and say, why do these risk management products only have to be agriculture and energy and financial and metals? Why can't we have a hedging tool for X, right? I won't name it, but you can imagine, because we all have phones and you can disintermediate and you have access to markets or market type structures, you can create products on a whole bunch of different things. And I'm sure some of you guys trade them, whether it's sports, whether it's politics, whether it's just pandemics and other things. And I think that'll be interesting to see how that policy discussion evolves, probably past my time. But there are a lot of pros, cons, and folks who feel very strongly about how our markets function, where they came from, and where they're going.
So will you all please join me in thanking the chair for speaking here in New York Law School. There's a reception right behind. For those of you who do want CLE credit, you must sign out. There's a table right behind us. And please join us all at the reception. Thank you all for coming.